Welcome to the Am I Free to Go podcast, where the Constitution isn't just paper, it's ammo. I'm your host, Soundrone with Soundbite News Media. And here, we don't just talk about your rights, we lock, load, and defend them. We expose censorship, spotlight real amendment battles, and bring you the stories the mainstream's too scared to touch. So, whether you're behind a mic, behind a badge, or behind enemy lines on social media, this is your front line in the fight for free speech. Strap in, speak up, and never ask permission, because around here, we know the truth. You are free to go. Episode 008 explains what it means when a cop says, "You're not under arrest yet. You're being detained either briefly or until things get more serious." We break down the two types: investigative, short and suspicious, and custodial. You're about to be bailed. Knowing which one you're in helps you say less and protect more.
Okay, let's dive deep. We've pulled together quite a stack of sources here. Everything from advocacy groups like the ACLU to, police department policies, legal histories.
Online discussions, even definitions of key legal concepts.
And the topic is navigating interactions with law enforcement in the United States. It's something many of us might face, and understanding your rights and the practicalities seems pretty important.
Yeah, it can make a significant difference. Our mission with this deep dive is really to cut through the noise, pull out the essential insights just from these materials we have in front of us.
Right. To help you feel more prepared, more knowledgeable about encounters with police, we're covering things like recording interactions, the difference between being stopped and being arrested.
And crucially, what you should and maybe shouldn't say. We're aiming to give you the key takeaways, maybe some surprising facts, all based strictly on these sources.
All right, let's jump right in then. One of the most, visible and sometimes contentious aspects today is recording the police.
The sources, especially the ACLU material, are very clear on this point. You have a constitutional right to photograph and film things that are, quote, plainly visible when you're in public spaces.
And plainly visible includes police officers and other officials.
Yes, explicitly. While they're carrying out their duties in public, legally speaking, the sources say this isn't really a gray area, it's a protected right.
Why is it so important, according to these documents?
Well, it's highlighted as a critical check and balance. Recording creates an independent record, one that's free from potential bias or faulty memory or just different people remembering things differently.
Yeah, we've all seen cases where the video is just absolutely central to figuring out what actually happened.
For sure. But the sources also point out a big friction point here. The ACLU notes what they call a widespread continuing pattern of officers telling people to stop recording.
And sometimes it goes further than just telling them to stop.
Yes, sometimes harassing, detaining, or even arresting people who insist on their right to record. So while the legal right seems firm,
the reality on the street might be trickier.
Exactly. The sources mention the ACLU's ongoing work on this, which kind of underscores that it's a continuing challenge to make sure the right is actually respected in practice. It's that tension, between the law on paper and what happens out there.
That tension seems like a recurring theme. Let's shift gears a bit. Understanding the type of interaction you're having with police. Not every stop is the same.
That's a really critical distinction. Sources like the law office of Thomas C. Tamasian and that East Lansing police policy help break it down. The two main categories are detention and arrest.
Okay, so break that down for us. What's detention mean here?
Detention is basically a temporary stop. An officer needs what's called reasonable suspicion.
Okay, what's that?
It's a specific legal standard. It has to be based on actual facts. The officer can articulate things they observe, suggesting you might have committed, are committing, or are about to commit a crime. It's not just a hunch.
Got it. And the purpose is just to investigate that suspicion.
Right, to investigate and figure out what's going on, what the next step should be. It's temporary.
An arrest? How's that different?
An arrest is much more serious. That's when they take you into custody. For an arrest, the officer needs probable cause.
Which is a higher standard.
A higher standard, yeah.
Yeah.
It requires more concrete, objective facts suggesting you were involved or out to be involved in criminal activity. It's a significant restriction of your freedom, and it lasts much longer.
So the key difference is the level of proof needed. Reasonable suspicion for a temporary detention, probable cause for a full arrest. One source mentioned a 2-hour limit for detention in Rhode Island.
That's right. That specific source notes that state rule as an example. But here's a really crucial point that applies across the board, highlighted in multiple sources. Whether you are detained or are arrested.
You have the right to remain silent.
Exactly. That fundamental right applies in both situations. You don't have to answer questions beyond maybe basic identification in some contexts.
Okay, let's zero in on that detention category for a minute. There's this specific term, a Terry stop. The Wikipedia source gets into this.
Yeah, the Terry stop. It comes from a 1968 Supreme Court case, Terry v. Ohio. Essentially, the court said that even without probable cause for an arrest, a brief stop and a limited pat-down for weapons can be reasonable under the Fourth Amendment.
The Fourth Amendment protects against unreasonable searches and seizures.
Right. So the court balanced individual liberty against officer safety using this idea of reasonableness, but there are rules for it to be legal.
Would have to be true for a Terry stop and potentially a frisk.
Okay, so the sources lay it out. The officer has to observe unusual conduct, making them reasonably suspicious that, 1, criminal activity is afoot, and 2, the person might be armed and dangerous.
Armed and dangerous, that sounds key.
It is. The officer also needs to identify themselves, make reasonable inquiries, and importantly, nothing should have happened during that brief stop to make their fear for safety disappear.
And the frisk part, that's the pat-down. Is it a full search?
No, definitely not a full search. The sources are clear. A frisk is strictly limited. It's a pat-down of your outer clothing, specifically looking for weapons.
Only weapons.
Only weapons. The justification is officer safety because they suspect you might be armed. It's not a general search for evidence of some other crime.
But then there's something called the plain field doctrine. How does that fit in?
Yes. This adds a wrinkle. If, during that lawful weapons frisk, the officer feels something through your clothing that they immediately recognize as contraband, say, drugs.
They can seize it.
Yeah.
Even though they're only looking for weapons.
Yes, but it has to be immediately apparent from the feel that it's contraband. The source does note, though, that how immediately apparent gets interpreted can sometimes be, well, a bit broad.
It sounds like the line between just talking to an officer, consensual chat, and actually being detained under Terry could be fuzzy.
It really can be. The sources kind of lay out a spectrum. You have a consensual encounter where no suspicion is needed at all. Then the Terry stop, needing reasonable suspicion. And finally, arrest, needing probable cause.
But knowing which one you're in the moment, maybe not so easy.
Not always obvious, no. And later court cases, mentioned in the sources, have actually expanded the Terry idea a bit.
How so?
Well, for instance, courts have said stops can be justified based on reliable info from an informant, even if the officer didn't directly see the suspicious activity.
Oh, interesting.
And another one, Illinois v. Wardlow, said that just running away without prompting in a, quote, high crime area can contribute to reasonable suspicion for a stop.
Wow, just running away.
Yeah, when combined with other factors like the location, the courts have allowed it. The legal landscape has definitely evolved, and sources also mention stop and identify laws in some states.
Meaning you have to give your name.
During a lawful Terry stop, yes, some states require you to identify yourself if asked.
Okay, back to that fuzzy line between consensual chat and detention. How do you know if you can just walk away?
That's a really practical question. And based on court rulings the sources discuss, like United States v. Mendenhall, officers generally don't have to tell you you're free to leave during a purely consensual encounter.
So they don't have to say, you can go now.
Nope. Which is why, as noted in that Reddit discussion we looked at, a common piece of advice is to just ask directly, am I free to go or am I being detained?
And the answer, or lack of one, tells you something.
It should help clarify your status. If they say yes or don't stop you from leaving, you're likely free to go. But circumstances matter too.
Like what?
Things like how many officers are there, if a weapon is displayed, if they're physically touching you. Even the tone of voice, these things can turn what seems consensual into a non-consensual detention, according to the sources.
Got it. And the sources also talk quite a bit about traffic stops.
Yeah, traffic stops are incredibly common, and they basically operate under these Terry stop rules from the moment those lights go on.
You're considered seized under the Fourth Amendment. You're not free to leave.
Exactly. And the rules here get specific. For officer safety, based on Pennsylvania v. Mims, officers can order the driver and passengers out of the car.
Even if they don't suspect anyone is armed.
Yes, just as a general safety precaution during the stop. Now, if they do have reasonable suspicion someone is armed, They can then frisk that person.
And search the car.
A limited search of the passenger compartment, yeah, where weapons could be hidden and accessed based on a case called Michigan v. Long. Again, based on reasonable suspicion, someone inside has access to a weapon.
And of course, if they see something illegal just sitting out in the open.
That falls under the plain view doctrine. They can seize anything illegal that's immediately visible without searching.
Okay, here's something else interesting from the sources about traffic stops. What happens after the ticket is written or the warning is given?
Right. This comes from Ohio v. Robinette. Once the official business of the stop is concluded, officers are not required to tell you, okay, you're free to leave now.
Really? So they can just keep talking to you?
Yes. They can continue asking questions, perhaps trying to get consent to search your car. The mandatory stop might end, but it can flow into a consensual encounter unless you make it clear you want to leave or don't want to answer more questions.
Which leads into this other idea.
Yeah.
Pretextual stops. What's that about?
This is a big one. It's when an officer uses a minor traffic violation, a broken taillight, maybe rolling through a stop sign, something minor as the reason, the pretext for stopping a car.
But their real goal is something else.
Often, yeah. Their real goal might be to investigate a hunch about something else, like drug possession. And the Supreme Court in Wren v. United States said this is generally constitutional.
How can that be constitutional?
The court's reasoning was that the officer's subjective motive doesn't matter as long as there was an objectively valid legal reason for the stop in the first place, like the actual traffic violation.
But the sources raise concerns about this, right?
Yeah.
Especially regarding profiling.
Absolutely. The concern highlighted is that pretextual stops can be used disproportionately against certain groups, essentially allowing officers to stop people based on factors other than their driving, using the minor traffic violation as cover.
That seems like a significant issue.
It is. The materials note that while it's allowed federally, some states have actually passed laws trying to limit pretextual stops if they're based solely on racial profiling or other immutable characteristics.
Okay, so given all these different scenarios, detention, arrest, Terry stops, traffic stops, let's talk about communication. What's the bottom line on what to say or not say?
Well, across almost all the sources, the single strongest, most consistent piece of advice is about your right to remain silent.
Just don't talk.
Pretty much beyond what's legally required, like maybe providing ID. But when it comes to questions about where you're going, what you're doing, or anything related to potential wrongdoing, silence is presented as your best protection.
How do you actually do that? Do you have to say specific words?
The sources suggest being explicit but polite, saying something clear like, I am exercising my right to remain silent, or I choose not to answer questions.
What about Miranda rights? You have the right to remain silent. When do officers have to say that?
Okay, so Miranda warnings based on the East Lansing policy and the Tomasian legal source are only required before a custodial interrogation.
Break that down. Custodial. Interrogation.
Custodial means you are in custody, not free to leave. This usually means you've been arrested, but it could potentially apply during a detention if the circumstances are very restrictive, like being handcuffed in the back of a police car.
And interrogation.
Interrogation means questioning that is reasonably likely to elicit an incriminating response from you. It's not just casual chat. It's questioning aimed at getting information about a crime.
So just being stopped or even being arrested doesn't automatically mean they have to read you your rights.
Correct. Only if they have you in custody and they intend to interrogate you about the crime. If they just arrest you and plan to book you without questioning, Miranda isn't required at that moment.
Now, the practical advice, especially from that Reddit thread, adds some real-world texture to this.
It does. For example, that common advice. Ask, am I being detained?
Yeah. Why is that helpful?
Because the answer clarifies your situation. If you're not detained, you should be free to leave. If you are detained, you know you're not free to leave, and you should probably stop talking.
But the Reddit thread also had a counterpoint.
Yeah, someone pointed out that during something routine like a traffic stop, you are being detained from the start. So asking immediately might just come across as confrontational without giving you much useful information right then. Context matters.
Makes sense. What about if you are arrested? What's the advice then?
The sources are very consistent here. Stay silent. Only provide basic identifying information needed for booking, like your name and address. And this is key. Immediately and clearly ask for a lawyer.
Explicitly ask for a lawyer.
Yes. The East Lansing policy actually confirms this from the police side. If a suspect invokes their right to silence, interrogation must stop. If they ask for a lawyer, interrogation must stop until the lawyer is present unless the suspect reinitiates contact themselves.
That Reddit discussion also brought up an interesting perspective that police training focuses on building a case, and anything you say
Can potentially be used against you. Even if you think you're innocent and just explaining things, you might accidentally provide details or inconsistencies that help them build that case. One comment referenced a book called You Have the Right to Remain Innocent.
So the idea is talking rarely helps you.
That's the strong implication from several sources. Even if you think you're clearing things up, you might just be giving them ammunition. So while some people in discussion suggested maybe being polite and cooperative for very minor things might avoid escalating tension.
The general consensus was still to be reserved.
Yeah, reserved, clear about asserting your rights, especially the right to silence and the right to counsel. And remember, providing a driver's license during a traffic stop, which is legally required in many places, is different from answering questions about where you've been or what you've been doing.
This all seems to tie back to a core legal principle, right? Due process.
Absolutely. Due process is fundamental. It's your constitutional guarantee, as mentioned in the sources, of fair treatment through the established legal system. It's meant to protect you from arbitrary government actions.
And all these rights, we're discussing silence, counsel, the standards for stops and searches. They are essentially due process in action during police encounters.
Exactly. Due process means the government has to follow the rules, respect your fundamental rights, especially when they're trying to restrict your liberty through detention or arrest. It's the framework meant to ensure fairness.
Now, we can't avoid a difficult but critical aspect highlighted in the sources, the issue of racial disparities in these encounters. The Wikipedia material addresses this directly.
Yes, this is a major concern discussed in the sources. They talk about how subjective factors in policing and potential implicit bias can lead officers to associate crime with race or base suspicion on things other than actual behavior.
And this disproportionately affects certain communities.
The sources indicate yes, particularly Black and Hispanic individuals. They cite findings from studies suggesting these groups are more likely to be stopped and significantly more likely to experience use of force, even non-weapon force, during stops compared to white individuals.
Even when trying to account for other factors.
Even when controlling for other variables, yes. The source mentions the idea of a racial double jeopardy playing out in these interactions.
And the impact isn't just physical or legal.
No, the sources discuss significant psychological and emotional harms. Stop and frisk practices are described as potentially being a public health issue, creating fear, stress, anxiety, and eroding trust in the police, especially in marginalized communities.
Which can lead to things like legal cynicism.
Right, a general distrust of the legal system and less willingness to engage civically. The sources also note particular impacts on individuals with mental health conditions or trauma histories.
There was also a specific concern mentioned about items related to public health.
Yes, things like clean needles for harm reduction programs or condoms potentially being seen as incriminating evidence during frisks, which could undermine public health goals.
Do the sources offer any solutions or ways forward on this?
They touch on some ideas being discussed or implemented, things like narrowing the scope of Terry stops, maybe optimizing stops based on the likelihood of actually finding weapons, collecting much better and more comprehensive data on stops, including ethnicity.
Data seems key.
It does, and incorporating stop data into broader health surveys to understand the community impact. Several states, the source lists, do now require police to collect stop and frisk data, and there are projects trying to analyze this data, like the Stanford Open Policing Project.
So there's an effort to understand and quantify these disparities, at least in some places.
It seems to be an ongoing process, yes.
Okay, so after taking all this in the rights, the rules, the practical advice, the disparities, what if you believe your rights were violated during an encounter? What should you do afterwards? The ACLU source had some practical steps.
Yeah, the first thing is documentation, and doing it as soon as possible while it's fresh in your mind. Write down everything you remember.
Like what?
Officer names, badge numbers, patrol car numbers, the agency they work for, exactly what happened, when and where it happened, any details you can recall.
What about witnesses?
Definitely try to get contact information for anyone who saw what happened.
And if you were physically hurt?
Seek medical attention immediately and take photos of any injuries. This creates a medical record.
Then what? Do you report it?
Yes, the source advises filing a formal written complaint. You can usually file this with the police department's internal affairs division, or if your city has one, a civilian complaint review board.
Can you do that anonymously?
Often, yes, the source mentions that possibility. And it also suggests contacting your local ACLU affiliate if you need more information or guidance on the process.
So document everything, get witness info, get medical care if needed, and file a formal complaint.
Those are the key steps outlined for trying to seek accountability if you feel your rights were violated.
Wow. Okay. We've covered a lot of ground here. It's clearly a really complex landscape, isn't it? You're balancing individual rights, the right to record, silence, due process against, the practical needs of law enforcement, officer safety concerns.
The specific legal standards like reasonable suspicion and probable cause, and then layered on top of all that, are these deeply concerning issues of racial disparities and the real-world impact these encounters have.
It really highlights that while we have this legal framework, how it gets applied on the street can be complicated, sometimes inconsistent. Understanding your rights, knowing these nuances, and documenting interactions seems vital, according to these sources.
It appears to be presented as essential knowledge for navigating these situations.
Which leaves us with a final thought, maybe something for you, the listener, to mull over. Given this gap we've discussed between the legal ideals and the practical realities, and especially considering the significant disparities highlighted in the sources, how do we, as a society, work towards ensuring that law enforcement interactions are consistently fair, safe, and respectful for everyone involved? And what role does being informed, understanding these complexities, play in that ongoing effort?
Thanks for tuning in to the Am I Free to Go podcast. Support the show by checking out our First Amendment gear, wear your rights proudly, and help us keep creating content like this. You can also join us on Patreon for access to uncut videos, outtakes, bloopers, and exclusive audio-only episodes. Don't forget to subscribe and hit the bell across all our channels. Links are in the description, and most importantly, we love reading your comments. Drop your ideas below, and you might hear your suggestion in a future episode.